This is our last video on the Bill of Rights, where we're going to clean up some loose ends, such as commenting on the right to privacy and a few other miscellaneous issues. It is not necessary, but it might be helpful if you have a copy of the Bill of Rights, like this one that was given to you in class. And it might be helpful if you have this packet of 23 Supreme Court case summaries that you've been provided with as well. Let's start with some of the miscellaneous issues that have been left over. You may have noticed in the other videos on the Bill of Rights that we skipped over certain amendments. That's because they're either just not that relevant to us today, or they don't appear on the AP exam, or for whatever reason, such as the Third Amendment, which says, "No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law." This was sort of a leftover indignation upon the part of Americans over how they'd been treated by the British Army over the years before our independence. So it was put into law that our government could never do to us what the British government did to us. To my knowledge, the Third Amendment has never been litigated, at least not up to the Supreme Court, so we're kind of mostly ignore it here. I did include a picture of someone that I thought had a very clever costume at a rally I went to once. It was supposed to be about just sort of a general protest about whatever you felt like protesting, and this guy dressed up as a British soldier, and he clearly had a negative opinion about the Third Amendment. I thought that was pretty clever and funny. Another amendment that we completely ignored thus far is the Seventh Amendment, which says, in suits at common law, that means civil suits, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any courts of the U.S. than according to the rules of common law. Basically, this is about civil cases, somebody suing somebody over money. And obviously $20 is no longer really relevant to us. It's been interpreted to mean any sort of large amount of money. If a case is about a large amount of money, then it will be decided by a jury. What's interesting is that this has never been incorporated, meaning it only applies in federal court. It doesn't apply in state courts. It has never appeared on the AP exam, so we don't really care about it much, so let's move on. And of course, since the Bill of Rights is the first 10 amendments to the Constitution, we have to talk briefly at least about the 10th Amendment, even though we've already studied it. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. We've studied this already, so to paraphrase, basically it means that any power that was not expressly given to the national government, nor prohibited to the states, are reserved to the states. This is where we get the notion of reserved powers and federalism. Just a quick reminder that the Necessary and Proper Clause and the 10th Amendment are mortal enemies. They're fighting all the time. If you strictly interpret the Necessary and Proper Clause, you end up with a concept called dual federalism, with both spheres of government or both levels of government kind of in the very well-defined areas, just attending to their own list of powers. If you loosely interpret the Necessary and Proper Clause, you end up with a more flexible division of power between the national and state governments, and you end up with a concept of federalism that we call cooperative or fiscal. And then finally we get to the 9th Amendment. Not very often talked about, doesn't come up much, because it doesn't say anything really specific, but it's important for the next set of topics that I would like to talk about. So let's read it together. The enumeration in the Constitution of certain rights shall not be construed, remember that word construed means to be interpreted or understood, to deny or disparage. Disparage means to belittle or say that something's not worthwhile or worth much. Others retained by the people. So it just says that the enumeration in the Constitution of certain rights. So the Constitution and the Bill of Rights lists a whole bunch of our rights, but that listing should not be understood to mean that other rights don't exist. please remember that the entire idea of a Bill of Rights was pushed by anti-federalists, that Federalists didn't think a Bill of Rights was necessary because they didn't think that the national government represented any sort of real threat to the American people, that most rights were held by state governments, and that most of the threat from the government would come from your state government, not the national government, so they thought a Bill of Rights was unnecessary. But they agreed to add one as soon as possible just to get certain anti-federalists to agree to support the Constitution and to get it ratified. When it came time to write up a Bill of Rights, Madison was, and this is one of his original concerns, was that he was concerned that if you list somebody's rights, that might sound like a good thing, but what if that list ends up becoming a limit of your rights? For example, you might have a list of things that you can do, and although in your mind that's not the end of all the things you can do, what if somebody comes along later and says that you can only do the things that are on that list? Well, Madison was afraid that if we list the people's rights, that someday that list would become the people's only rights, and that they wouldn't have any other rights other than what's on the list. So he added this amendment that acts as sort of a safety valve. Just because there are certain rights that you can think of that aren't in the Bill of Rights, it doesn't mean you don't have those rights. It just means they weren't listed, and you still have them. So what kind of things might he have been talking about? Well, I think we'd all agree that we have the right to be alive. In fact, the Due Process Clause of the Fifth Amendment says we have a right to life, liberty, and property. So we have a right to be alive, to live. Do we also have a right to die? If we do you have the right to get somebody to help you die? That's called assisted suicide. If you have a right to be alive, well then, you could argue you have a right to be healthy. Does that mean you have a right to something called health care insurance, like that didn't exist when this was written? Do you have the right to refuse health care under circumstances? Do you have the right to be educated? The Supreme Court's decision in Brown versus Board came very close to saying that was a foundational right of Americans, but it's not in the Bill of Rights, it's not in the Constitution, and the Supreme Court didn't come right out and say it, but a lot of people think that in the modern times you can't really be a productive member of society without at least a high school education. So do you have a right to it? Unclear. And if you have a right to be educated, do you have a right to be not educated? You have to live someplace. Do you have a right to own a home? Does that mean, if you do, does that mean the government has to help you afford a home? If you do or don't have a right to own a home, do you have a right to be homeless? Do you have a right to travel? If so, do you have a right to where do you have a right to travel? When? How? Do you have a right to marry, to have children, or to not have children? Do you have the right to have a job, a profession, a career? What about the pay of those things? Do you have a right to a certain minimum level of income? Do you have a right to some sort of at least the amount of income that would keep you alive? There are a ton of questions that our founding fathers didn't want to get into, didn't think it was the appropriate thing to have government involved in. But times have changed, and now we ask ourselves a lot of these questions because times have changed. You take a lot of things for granted living in America because you're so free to do so many things. I just threw in a couple examples here from Afghanistan. Back before we invaded in 2001, the Taliban ran Afghanistan under very conservative interpretation of Islam, and girls could not go to school. Men did not have the right to shave. You couldn't watch TV. You couldn't listen to music. You couldn't do a simple thing such as flying a kite. So there are lots of rights that didn't get listed in the Bill of Rights, and I'm just showing you this slide to just sort of get you to realize that no matter how hard you try, no matter how long you take, it probably just isn't possible to list all the rights you have as a human being, which was what motivated Madison to write the Ninth Amendment. And the main issue I wanted to get to in this video is, of course, the right to privacy. You'll remember in class that we studied the Griswold case from 1965. I gave it to you as an example of very loose construction of judicial activism. Remember, the Griswold case was used by the Supreme Court to pronounce a brand new right that had never existed before, a right to privacy, by examining several amendments in the Bill of Rights that seem to have some sort of suggestion of you having the right of privacy from the government. There's lines in the First Amendment, the Third Amendment, the Fourth Amendment, the Fifth Amendment, and then, of course, there's the Ninth Amendment that we just looked at that says just because the Bill of Rights doesn't list a certain right doesn't mean you don't have it. And so very importantly, the 1965 Griswold case announced a brand new right that had never existed before, which is probably a good thing. I'm not saying it's not. It's just that sometimes these things can have unpredictable outcomes. For example, once this right to privacy was established, it wasn't very much of a leap a few years later when the Supreme Court extended the right to privacy from Griswold, which was about the right of married couples to find out about contraception and birth control. In 1973, a case about abortion came up to the Supreme Court, and the Supreme Court pretty easily said, well, you have this right to privacy. And we looked at the history of abortion and how it's been practiced and why certain states have laws against it at the time. And they extended the right of privacy to cover pregnant women and their choice of whether or not to have children. This is one of the most controversial cases in American history. We're still arguing about it today. It is a required case by the College Board, and it is briefly described in that packet of Supreme Court case summaries I've given you. If you do read that or do some of your own research, you'll know that Roe v. Wade does not create an absolute right to have an abortion. It does allow for the possibility of state governments imposing various restrictions starting in what it called the second trimester. Most pregnancies are 9 to 10 months, so if you divide them up into 3 months each 3-month period is a trimester. We don't really talk about that anymore. Remember, this is 1973, and medical science has come a long way since then, but back then they talked about trimesters. In the first trimester, or the first 3 months of pregnancy, the Supreme Court said that it was purely up to a woman whether to carry the child to term or not. But the Roe v. Wade decision also said that once you get past that, then the possibility of the government restricting the right to an abortion for the health of the mother or for the health for the potential of unborn life, that it was possible for state governments to impose certain restrictions as long as they did not outright ban abortions. Like I said, it was a very controversial decision almost immediately, and several states tried and have been trying for, 40 years now, almost 50 years, to put limits on a woman's right or ability to get an abortion. And here's one case, just one of many examples that we could pull up. 1989, Webster versus Reproductive Health Services. It was a case out of Missouri. The state of Missouri passed certain restrictions on getting abortions. One of them was a state-run medical agency or hospital could not perform an abortion, and the Supreme Court said that's okay. Missouri law also required that for anyone who came to them, any pregnant woman that came to them, that they would have to perform a viability test in any pregnancy case past the 20th week of pregnancy. Viability means livability of the fetus outside the womb. As you know, some babies are born prematurely. If it's a few weeks, it's not a big deal. Viability means, can the baby be born if it's born at that moment? Obviously, if you're close to the full 9 or 10 months, then there's usually not much of an issue. But if a woman comes to a doctor and she's 4 months pregnant, let's say, this law required a doctor to perform a viability test. That means to take some sort of impose some sort of test that would result in could the baby be born now. I think what I recall about this is was an attempt by people who were against abortion to make sure that any woman who was pregnant and who went to a doctor for prenatal care, that they would have, at some point in their pregnancy, they would be told the baby would live if it were born now. And the idea was that would reduce the number of women choosing to get an abortion. The Supreme Court, in this case, permitted both of those requirements. In a somewhat more famous case, a few years later in Pennsylvania, law was passed that required a 24-hour waiting period for anyone seeking an abortion. That meant that if you went to a hospital or a clinic or whatever to get an abortion, they couldn't perform it right away. You had to come back a day later. It was an attempt by abortion opponents to get women to have second thoughts. Instead, abortion on demand is obnoxious to some people, so the idea was force women who want an abortion to have to go home and think about it for 24 hours. It also required for minors who were seeking abortions to get parental permission, and the Supreme Court said those two requirements were okay. There was a third requirement under the Pennsylvania law that said a woman had to notify her spouse that she was seeking an abortion. And the Supreme Court ruled that particular part of the law was unconstitutional, that it was an undue burden. That undue means unnecessary, and a burden means some sort of obstacle, that it was an unconstitutional restriction on women, that they had to inform their husband that this was happening, and they struck down that part of the law. Other references to privacy in the College Board's curriculum for this course mention the USA PATRIOT Act. You've probably never heard of it because now the 9/11 attacks are almost 20 years ago. But shortly after the 9/11 terrorist attacks, our Congress passed kind of an update to our anti-terrorism laws and our federal and investigatory laws. Basically, you've all heard of the FBI, the Federal Bureau of Investigation. Well, before 9/11, what happened? What the FBI mostly saw as its job was to investigate crimes after they've happened and catch the bad guys. Well, 9/11 taught us that, investigating crimes afterwards is okay most of the time, but what if the crime involves thousands of people dying? It'd be kind of nice if the FBI had the tools, the techniques, the legal permission, the legal ability to investigate bad guys before they have committed their crimes. And the USA PATRIOT Act, it's kind of a fun law. If you can look it up, and because each of the letters in USA PATRIOT, all of those letters are it's actually an acronym, so all the letters stand for something. Kind of clever. So anyway, the law was long and detailed and contained all sorts of different updates and changes to the way the FBI does their job. One of them was what were called sneak and peek warrants were legally permitted, meaning the FBI could get a warrant to search your property and would be able to search your property without telling you first. Roving wiretaps because of changes in technology. When I was growing up, the only phone you had was attached to the wall, and you couldn't carry it around with you. Well, now of course you can carry phones with you. You can communicate with lots of different kinds of devices. And roving wiretaps. A wiretap is an ability to listen in on phone calls. And notice the word wire back when all phones were landlines. Roving means moving around. So roving wiretaps were permitted so that the FBI could track somebody and their communications, no matter what device they were using, with just one warrant instead of a warrant for each device. The USA Patriot Act also gave the FBI sweeping access to a person's phone, email, medical, business records, et cetera, et cetera, et cetera, just with something called a national security letter that the FBI could sort of issue itself and didn't have to get a judge's approval like you would with a warrant. There were tons and tons of other stuff in the USA Patriot Act that were very controversial and continue to be very controversial. Some of these provisions in the original act have expired and are no longer valid. Some have been extended. Some got extended and then expired. And anyway, my understanding is that the USA Patriot Act eventually did expire, and it was replaced by something called the USA Freedom Act, which is another very clever acronym. Each of the letters in the words USA Freedom stand for some word. The USA Freedom Act was passed in 2015, basically as a giant sort of replacement or modification of the original Patriot Act. And I'm guessing that the College Board is mostly interested in this because of its relationship to a kind of a major scandal that was produced by the whistleblower named Edward Snowden. You may have heard of him. He worked for the Defense Department, and eventually stole a bunch of information and fled the country, and it eventually all got published on WikiLeaks. Basically, his information revealed that our national security agency, the NSA, had secretly been collecting just enormous amounts of data about Americans, mostly phone call information from people like Verizon and AT&T and stuff. Now, they weren't listening to the contents of their phone calls, but they were collecting data about your phone calls. So they had just this enormous database going back years, apparently, of who was talking to who, which phone numbers were calling which phone numbers and talking for how long. And they were using that to try and track and catch terrorists. But still, most people saw it as an invasion of Americans' privacy. They thought that they had been no business doing this, that it was illegal, and that the USA Freedom Act was a rewrite of the Patriot Act, and for one of its purposes was to stop this from happening. Now, supposedly, the NSA's practices have changed, and they're not doing this anymore, but there are lots of watchdog interest groups out there, like the ACLU, the American Civil Liberties Union, that we studied back during the Unit on Interest Groups, who claim that there's still some nefarious and evil secret stuff going on, that our Fourth Amendment's freedom from unreasonable search and seizure is being routinely violated, and that this law needs to be fixed and various other laws need to be fixed. It's an ongoing issue. There's no way we could explore every possible detail of it. It's just too big and complicated. But you are now aware of the issue, and in case it comes up on a test someday, now you know. And this is the last of my videos devoted to the Bill of Rights, and I hope you have found them enjoyable and informative. See you later.